Thank you everyone for joining. This is a free lecture on barristers criminal law course. We don't provide any legal advice during our tutoring sessions. This is just to give you an idea how you should prepare for your next coming exam. So you type in the Google NCA online teacher. This website will open up and there are some other tabs. So this is the first tab is called free recordings. It has free recording on Barrister Civil Procedure. It also has free recording on Barrister's Family Law. Once your instructor has completed today's lecture, most probably within a week or so, it will also be uploaded here. So if you want to help anyone, please feel free. These are freely available and they are also connected with YouTube. Then this is our initiative of connecting Canadian lawyers. Some of them are obviously senior lawyers, but most of them are also those members who have been attending our classes just to promote them for more visibility of their services. So we can also mention there, I think probably there are 86 law firms who have joined that. Now, this is your third source, which is called Ontario Bar. The first five options are for solicitors live classes with video recording. Second option, solicitor recording with notes. Third option, solicitor recordings only. Fourth option, solicitor single course and then solicitor crash course. Then is the barristers live classes. So barristers live classes with video recordings. This is the lecture you are having now. So if you decide to join today after the lecture, you will attend all the live classes on criminal law, all the live classes on civil law, and then many more classes are still left on professional responsibility and ethics. Family law, your instructor has already completed, but you will get the very detailed, the updated recordings for the family law lecture as well. So this is the option which 90% candidates like to have because then you can attend the live classes as well. Many members say, Sir, I'm working on Saturday or some other day. Should I join it? Yes, my suggestion is yes. Why? Because then you have the option to attend and ask any question. Second option is called barrister's recording with notes. In this option, there is no option to attend live classes. You will only get access to notes and recordings. And third option is called barrister's recordings only. The price is $750. In this option, you will get only recordings and there are no notes. So once you have purchased that, and then on the right side, you will click sign in on the right side. Please look at the screen. And then you will see your name here, whatever name, username you have given to the website, and then you click access courses. You will be able to see that course which you have purchased. I can see all 66 courses, but you will be able to see your course. Then you select your course, Barristers Live Classes, because this is what is happening now. And then these are the recordings, like the latest recordings. You can see lesson 1, Family Law, June 2026. Lesson 2, Family Law, June 2026. Lesson 3, scroll down and then you can see all the classes. So maybe 2, 3 lectures may be uploaded once it is if it is not there. And then you scroll down and then you can also go to page 2 of 9. So there are 9 pages. Every page has 15 recordings. Every recording is around 2 hours, 2 hours, 30 minutes. So you have more than 200 hours of recordings. You have access to June recordings. You also have access to February recordings. What is the difference between the two? February recordings are our brief version. In February, Ms. Hannah conducted 45 hours of classes because we have feedback. Some candidates say we want like 45 hours. Some members say we like 65 hours. So for June and November, we conduct 65 hours. For February, we conduct 45 hours. And then These are called instructor's notes. Your instructors have prepared the notes. They are very helpful. Many candidates like it. Yesterday also, three members said that they wanted to purchase it. Please be advised, we don't sell these brief notes or the recordings. So our first advice is that you should read your material, which is a copyrighted material. Please do not read that material in the class. Please do not read that material publicly. That is your copyrighted material. In our classes, we do not use the LSO material. That is your contract with the law society. So your instructor will use her brief notes, civil litigation, PR and legal ethics, criminal procedure, family law, and all that. So, and then there are some sample questions available also. Um, Sample questions also have answers. So you can see civil litigation answers with explanation, Hannah's family law charts as well. We will be adding some more charts for the criminal law or the civil law as they are ready. So we are in the process of adding more charts as well. And this is your criminal law answers with explanation. So that is the brief introduction. If any member has not joined so far, if you have any questions, please message me after 5 hours and then I will be able to help you. Thank you. If there is any new member who has joined and they don't know how to access the material, the recording, this is how we work together. My job is to guide you how to access if you have any problem, and then how to please do not use two different devices. The website can block you. It is very sensitive. You can use your laptop and phone, but please remember one device at one time. If you sign in from two different devices at the same time, the website believes that the security is compromised and then it may block you. Once website blocks you, then we are unable, then it takes, 5 days to investigate that where the username was used. So that's the thing I just wanted to say. Thank you. Anna, please.
Yeah. Good
You
morning,
can stop
everyone.
sharing the screen.
Okay. Yeah. Good morning, everyone. I welcome you all to our first free and introductory session on criminal litigation. My name is Hannah. I'm a barrister and solicitor in the province of Ontario, and nothing I discuss today constitutes legal advice. It does not give rise to any solicitor-client or barrister-client relation between us, and that includes fiduciary, contractual, professional, and agency relation. Whatever I will discuss over the course of next few hours is only for educational purposes. In addition, you're strictly prohibited from recording this session, including transcribing this session. And in the event you do so, not only will you be breaching my privacy, but you shall be breaching the privacy of every single candidate attending today's session. Please note the materials that I have prepared exclusively belong to me. They can neither be printed nor be downloaded and must not be accessed in any unauthorized fashion. Furthermore, I request you all not to ask any questions stemming from the examination content as defined by the Law Society of Ontario in your respective law licensing agreements, lest it jeopardizes the process for other candidates. With that said, I will start sharing my screen and we are going to start with criminal litigation. You see, before we get into the nuances of criminal litigation, it is important to understand the life cycle of a typical criminal litigation file. What happens when cops receive a 911 call? Because when we talk about criminal litigation, the actual life cycle of a file or how the file evolves, in fact, starts from there. So let's say cops receive a 911 call and an offense is reported. Cops usually reach the scene of the crime and they investigate the matter. Based on their investigation, they either issue and execute warrants, or once they investigate, if they find there is no charge, then the matter ends there. I'm going to talk about what is a charge. And if they think that there is a charge involved, at that time, the accused is charged. I'm going to talk about exactly what is a charge screening form, what is a crown brief, who prepares the charge screening form. I'm going to come to that. So I know you will have questions, but let's first focus on the life cycle of a file. Once the cops have identified the charges, they prepare what is known as a crown brief. Plenty of candidates think that the charge screening, that the crown brief is prepared by the crown, because obviously it's called the crown brief. No, crown brief is prepared by the police. So cops prepare the crown brief. Crown brief is essentially disclosure. They would talk about the circumstances of the offense. What did they collect? Who all were present? Pretty much a snapshot, a written snapshot, which is extremely detailed, by the way, that is prepared by the cops. Once the crown has the brief in front of it, and they see, okay, this is what we have, they usually look, they will go two ways. Either they'll say this is too sketchy, we don't have enough, withdraw charges, there's nothing that can be done, because literally they're just two sentences in the crown brief. Or there is no reasonable prospect of success if we were to pursue this matter, because we don't have enough details, there is not enough evidence, so the charges are withdrawn. In case the crown brief is detailed and the crown thinks that there is merit, that's the time they start prosecution process. Now, prosecution process, there are three parts to it. Either it leads to a pre-trial release, which is also known as bail, which means the accused is let go, right? And because bail, not jail, is the norm that we follow in Canada. Or the accused pleads guilty, in which case they plead guilty to a lesser offense. And I'm going to talk about guilty plea. And it is essential that you understand guilty plea with the professional responsibility aspect of guilty plea. Or there is preliminary inquiry. And it is important to understand that preliminary inquiry is not available as a matter of right. It is available only under special circumstances. And I'm going to talk about it as we progress. We have an entire session planned on preliminary inquiry in terms of when it is offered, who conducts the preliminary inquiry, where is it conducted, what are the possible outcomes of preliminary inquiry, etc., etc. Right? After the preliminary inquiry is conducted, and if it is available, or once the accused has been let out on bail, both these result into trial. So there is bail, the person is out. That does not mean the charges are extinguished or they're gone or this person is now allowed to walk scot-free. No. Pre-trial release or bail will also lead to a trial, and preliminary inquiry will also lead to a trial. Now, when the matter is tried, there can be two outcomes: conviction, acquittal. If there is conviction, the next stage is sentencing. So you've been convicted. What's the next stage? Next stage is sentencing, which means although you have been convicted, what kind of sentence would be given to you? What kind of sentence would be pronounced? And in this case, once again, there is some amount of discretion. We look at the purposes of sentence, what are the different kinds of sentences that are available, so on and so forth. Or it leads to an acquittal. Now, you can appeal against both the conviction and the acquittal, and this is where you have the appeal. When we talk about appeals, how the appeals progress, whether it is a Section 813 appeal or a Section 830 appeal. We're going to talk about it when we start discussing appeals. However, this is this is how a typical life cycle of a criminal litigation file looks like from the time the cops receive the call till the appeal. Any questions here? Or are we good? Any questions? Okay. Now, for those of you who have questions, there are two ways. The best thing to do is to write down your questions, and after the class is over, like once I'm done teaching, I always stick around and you can all ask all your questions there. So that is one part. The other thing is you can put your questions in the chat box, and as and when I take a look at it, I'd be able to answer them. However, if there is a pressing question, you can ask in the class, and if it is relevant from the point of view of what we are discussing, I would be happy to answer. I am aware as lawyers, we are very, very inquisitive and we obviously have lots of questions, as we should. But some of the questions stem from intellectual curiosity. And while I would love to answer those questions, there might be a possibility when I say, no, not required, which essentially means let's not go down that path because it's not relevant to what we're doing. However, the fact that you have a question, I like that. Now, let's look at the basics of criminal procedure. You see, it is important, and I will go painfully slow when it comes to basics. For the simple reason, for those of you who are with me in family law, we actually ended up doing basics for at least 2, 3 sessions. For the simple reason that if there is any confusion here, if there is any problem at this level, then your understanding of the entire criminal law procedure gets impacted. And that's where you lose out on litigation process. You lose out on knowledge of law aspect of the exam. And both of them are extremely crucial. So we are going to spend some time focusing on the basics of criminal procedure. One second. Now, let's look at, okay, yeah. When we talk about criminal procedure in Ontario, we are looking at criminal procedure for adults and criminal procedure for young people, also known as youth, right? These two look different. And before we deal, and we are going to look at each one of them separately. So that's the first thing. I'm not going to combine the two, right? So, and we're going to start with for adults. Before we look at how a criminal law file of an adult works, we need to clarify 4 things. Why? Because how a criminal litigation file will progress will depend on these 4 factors. Number one, type of court. Number two, type of trial. Number three, type of charging document. And number four, type of offense. Once again, a criminal litigation file for an adult depends on these 4 factors: type of court, type of trial, type of charging document, type of offense. Who is going to repeat this? I need 2, 3 candidates to repeat this, please. What are the 4 factors that you need to keep in mind? Yes, Imi.
Only here with type of
One
court.
second. Okay, one second. Polya, Imi raised her hand, then I'll come back to you. Yes, Imi, I need 4 factors.
Yeah, so the 4 factors are the type of court, the type of trial, the type of charging document, and the type of offense.
Beautiful. Yes, Polya, your turn.
Type of court, type of trial, type of charging document, and type of offense.
Gorgeous. Yes, Rima.
Type of court, type of trial, type of charging document, and type of offense.
Yes. Yes, Nia, you're absolutely right. Before I progress, there is a person by the name of OG who has just entered the class. Can you please identify yourself? I'm going to pause the recording till we don't know who this person is. So these are the 4 factors that will determine how a criminal law file progresses. Let's go back. Thank you for sharing that, everybody. Now, let's look at type of courts. Now, in Ontario, we have 2 types of courts, right? In criminal law specifically, Ontario Court of Justice and Superior Court of Justice. So you have SCJ and OCJ. OCJ, which is Ontario Court of Justice, the rules that govern are criminal rules of OCJ. This is a typical provincial court. In this case, there is a judge who sits on a trial. So your provincial courts, where you have statutes like Highway Traffic Act, when you get a traffic ticket, it's essentially, and the matter gets litigated, it is before OCJ. Anything that stems from a provincial statute, any criminal issue that stems from a provincial statute is litigated before OCJ. Now, sometimes any municipal bylaw infraction also gets litigated before OCJ. Excuse me. So, it is a provincial court. There is a judge who sits on the trial. And like I said, this is a court where the rules of OCJ, they govern the process. SCJ makes, or the rules of criminal proceeding rules of Superior Court of Justice typically govern SCJ. SCJ is a court of inherent jurisdiction where, thank you, right? Where, again, very specific matters are litigated before SCJ. So anything that stems from your criminal code, for instance, will go to SCJ. Now, when we talk about types of trial, so there are 2 types of courts and there are 3 types of trials. Okay, remember this: 2 types of courts, 3 types of trials. There are 3 modes of trial. First is OCJ, which is only one judge, no jury trials. However, preliminary inquiries are conducted at OCJ. During these, as I will progress, you will see that I have put footnotes in these notes that I've prepared. These footnotes are important where, I have explained a term and I don't want to make it a part of the main notes, and therefore footnotes appear. So what is preliminary inquiry? Preliminary inquiry is essentially a judicial hearing that is only available when the accused has committed a serious offense, right? And I have a specific name for preliminary inquiry. How many of you have gone to a swimming pool? Seen, I know it's a weird question, right? In the middle of criminal code, criminal law, I'm talking about swimming pool. Now, if you see, they usually have 2 types, right? There's the kiddies pool and then there's the adult pool, right? So you first learn, or when you're up to a certain age, you swim in the kids pool, or before you jump into adults pool, correct? Preliminary inquiry is that kiddie pool, right? So if it is a kiddie pool, it's going to be conducted before OCJ. Please note, preliminary inquiry is never, never, never conducted before SCJ. And I'm going to ask this question so many times that by the time you're done with me, you will know this in your sleep, that at no point in time preliminary inquiry is conducted before SCJ. So it is a pool where you learn how to swim. You see if I like swimming, right? Similarly, preliminary inquiry is that stage where you're trying to assess evidence. How much does the other person have? How much does Crown have? Is there a reasonable prospect of success? Do we have enough to sort of jump into the adult pool of a full-blown trial, so on and so forth. So this only is given where the magnitude of the offense is huge, it's immense, right? So if it is really big, that's when you will have a full-blown trial. So preliminary inquiry is that stage where the nature of the offense is grave. So that's number one. It is always conducted before OCJ, and it is the stage where you assess the evidence to decide the next steps on your criminal litigation file, right? So OCJ, one judge, no jury trial. Preliminary inquiries are conducted. Then the second type of trial is before Superior Court of Justice. This is a judge alone trial, which means there is no jury that sits on it. And the third type of trial is judge and jury trial, okay? Where you'll have a judge and you also have a jury. And we're going to talk about jury trials because jury trial is important from the perspective of jury is the trier of fact and judge is the trier of law. So I'm going to talk about jury trials. Once again, two types of courts, three types of trials. OCJ, SCJ. OCJ makes criminal rules of OCJ. SCJ makes criminal proceeding rules. Three types of trials. OCJ, only judge, no jury, preliminary inquiries take place. Second, Superior Court of Justice, judge alone trial. Third, Superior Court of Justice, judge and jury trial. Any questions? All good? Somebody by the name of iPhone has entered the class. Can you please identify yourself? Who's going to repeat this? Types of trials and types of courts. I need three candidates. Yes, Dia. Then Jugraj. Dia,
So
unmute.
there's two. There's OCJ and SCJ. OCJ follows the criminal rules of OCJ. SCJ follows the criminal proceeding rules of SCJ. OCJ conducts PI, which is preliminary inquiries. There's only a judge and there's no jury. SCJ, you can have a judge alone or you could have a judge and a jury.
Superb. Jugraj?
Yeah, two types of courts, OCJ and SCJ. OCJ makes criminal rules, and then SCJ criminal proceedings, and then three types of trials, OCJ, SCG, and SCJ. The OCJ only the prelim inquiries, and then only one judge and no trials, and then SCJ only judge, and then SCJ only judge and trial.
SCJ only judge and the other one judge and
Jury.
jury. That's right. Thank you very much. Yes, Parisa?
We have two types of courts, OCJ and SCJ. OCJ is where preliminary inquiries take place. They are just with the judges, no juries. SCJ is for can be with judge or with judge and jury at the same time.
Lovely. Yes, Palak?
There are two types of court, OCJ and SCJ. OCJ can make criminal laws on criminal rules, and SCJ makes laws on criminal proceedings. SCJ, the preliminary inquiry is conducted only in OCJ. SCJ, there are three types of trials, two types of trials, judge alone trial and judge and jury trial.
Yes, thank you very much. Those of you who are joining the session for the first time and might not sign up with us, I think by the time you'll be done with this session, at least you will remember these things. These are the basics of criminal procedure which you cannot forget. And for those of you who are with me already, most of you are already with me. You know we will be doing questions. You know I will be conducting a mock test, and you know I'm not going to take it easy, right? So, Palak, if you have no further questions, I mean, can you please put your hand down? Because otherwise I won't be
Sorry.
able.
Yeah. Sorry.
That's okay. Now, there are two types of charging documents: information and indictment. The word indictment is confusing, right? Because this word indictment is used in multiple contexts. So people tend to get confused. Oh, which kind of indictment we are referring to? And the answer to that is read the question and you would know whether it is Crown decides to proceed by way of indictment, or is it referring to a charging document. When you will read the question, it will tell you how the term is being used. When we talk about a charging document, there are two types of charging document: information and indictment. Let me show them to you how they look. Um, yeah, I think this is a good document to see. Now, this is how your typical charging document would look like, right? It will talk about province of Ontario, which region you're situated in, and this is this is Toronto, so we are talking about Toronto. Basically, it will tell you the details of exactly what happened, right? So a charging document is something that will give you what has exactly occurred. And there are two types of charging documents: information and indictment. Okay, let's first talk about information. Information is a sworn statement that is given by the police officer. Sworn statement means it's under oath. And if you lie on oath, that is a massive criminal offense called perjury. So it is a sworn statement, which means it's prepared under oath. It's given, uh, I wouldn't want to use the word FIR, Oshi, because an FIR is the first. Okay. In order to simplify that for you, yes, you can take it as an FIR. But a charging document is different actually. But okay, if that helps. Information is prepared in case of both adults and young people. So this information document that you have, I think it's either Form 4A or 2A, that is prepared both for adults and youth. Information is always submitted before Ontario Court of Justice. Information is not submitted before Superior Court of Justice. So you might ask a question: what is filed or submitted before Superior Court of Justice? That document is called, or that charging document is called indictment. Okay. The matter proceeds to the Crown Counsel, and it is the Crown Counsel who decides whether they are going to pursue the matter or they're going to withdraw charges, right? And charges are withdrawn only after certain criteria have been met. So the matter then reaches the Crown. The Crown, where, it looks at the issue from an entirely legal standpoint, and then they decide the next steps. And if they choose to withdraw the charges, they can only do so under certain circumstances and after all the criteria have been met. The court relies on information every single time the accused appears. So every single time the accused is brought to the court will rely on the information. And what is this information? It will contain, like I showed you, the details of the offense or the outcome of preliminary inquiry if it's taking place, any plea that has been made by the counsel, crown proceedings, etc. So it relies on this document every single time the accused has to appear before the court. Now, when do you give information or when is information prepared? Information can be given in two cases. Number one, if the informant has personal knowledge of the offense. So the informant can be an individual as well. If they have a personal knowledge, which means they were a bystander when the offense was committed. They knew about the offense. They witnessed the offense. So in this case, the information is prepared by the person who has personal knowledge of the offense, right? Or the informant has reasonable grounds to believe that the offense has been committed. So information is given in two cases. Number one, when you have a personal knowledge of the offense, and number two, when the informant has reasonable grounds to believe that offense has been committed. So let's look at this. X committed an offense. Y saw him commit the offense and calls 911. Z arrives on the scene of the crime. Z is a cop. Z arrests X if the offense is serious, in case of a non-serious offense, and if there is any likelihood that X has committed the offense, then Z charges X by preparing a charging document. The purpose of arresting X is to get information from X. So X commits the offense, Y saw him commit, Y called 911, Z comes to the scene of the crime or, the crime scene, arrests X. If the crime is serious, they're retained. If the crime is not serious, then they prepare, whatever information they need and X is let go. Now, what does it mean to charge a person? Because I told you here, I'm going to explain what charge actually means. You see, charge simply means to provide a sworn statement containing the charges against the accused. That means the offense that the accused has conducted. So we say this person has been charged under section so and so of Criminal Procedure Code. So it basically mentions what is the nature of offense that you have committed and under which section of that criminal code does that offense fall under, right? And then how do you prepare this document? The police officers spoke in detail with the accused. This is where, they're trying to get the information from the accused. And after having this conversation, they come to the conclusion what offense has been committed. And then, they sort of point out the sections of criminal code. Now, what is indictment? Indictment is for serious offenses. The word that we use for indictment is prefer. So you file an information, but you prefer an indictment. Please note, we are going to use the word prefer here, but it simply means filing, right? It is preferred always in SCJ. So my question is, can I prefer an indictment in OCJ?
No.
No.
You're very sure?
Yes.
Said prefer.
Prefer an indictment in OCJ?
No.
Why?
It's for serious offenses.
You very sure there?
Yeah.
But what if a preliminary inquiry needs to be conducted? If it's for serious offenses, I can conduct it before SCJ.
No, that would be an OCJ.
Are you 100% sure on that?
Yeah.
Is she correct, guys? Is Dia correct?
Yes.
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 It's
So
only
you mean I was wrong? That's what you're trying to say. I was wrong.
Yes, because preliminary inquiry is available only in OCG.
Yeah, sometimes like you think I'm wrong, and then go like, yes, of course I was wrong. You have to ask me, what have you been eating since morning? Did you drink anything? What's wrong with you? Thanks, Yoshi. So, like I said, indictment is always preferred before SCJ. So that's one. And it is only for grave offenses, right? And now the question is, what if the matter proceeds from OCJ to SCJ? What if the matter makes that jump? In that case, in SCJ, you are still not going to file information. You will still prefer an indictment. Sometimes the matter flows from OCJ to SCJ, and you would want to know when does that happen, and I'm going to talk about it in a minute. But let's talk about when the matter flows from OCJ to SCJ. Even then, indictment is preferred. Information is not filed, not preferred before SCJ. Okay. Now, it requires the written consent of the Crown Counsel, who acts as the Attorney General, agent of the Attorney General, and the Crown Counsel must sign the environment. Would both docs will carry the same information? Yes, because it's essentially what exactly transpired at this crime scene. Indictment is drafted and signed by Crown Counsel, and when that is done, it's called preferred. So the indictment is prepared because the matter has to go to Superior Court of Justice because the matter is really serious. In this case, the Crown Counsel signs the indictment. Once the indictment is drafted and the Crown Counsel has signed it, it's called preferred. Okay? Now, how are you going to select which charging document? I already told you, less serious offenses, information, but grave offenses, indictment. However, there is an interesting area which I call, you know, which is essentially called a hybrid offense, right? Now, a hybrid offense and I'm going to talk about it later. It's where the Crown decides how to proceed in this case. So it could be a case where the Crown decides we are going to proceed by way of an indictment. Now, which means the accused now will be taken before the Superior Court of Justice. So the choice of charging document depends on the nature of the offense that I already explained, right? Serious, you'd have indictment. Less serious, you'll have information. But there is another category of offenses which is known as hybrid offense, right? Hybrid offense is the kind of offense where the Crown decides how they're going to proceed, right? So the Crown sits, looks at what they have before them, history of this person, what is the offense, what is the evidence available, and they go like, I don't think we need to proceed. Or there's enough and more on this, let's proceed. And in this case, if the Crown takes a stand, they're going to proceed by way of indictment, and then the matter will be heard, once they proceed by way of indictment. In this case, because the Crown has taken that call, they're going to file indictment. Okay? Now, there are two types of indictment. Like I said, one is the charging document, and the other one when the Crown decides to proceed by way of indictment. Now, Yes, Yoshi. I'm going to talk about it. If you'll give me a minute, I'm going to talk about each of these offenses. I understand the curiosity. Believe me, today I'm going to answer, like I said, I'm going to lay good, explain everything in detail in terms of basics. Then we're going to proceed. But types of offenses is the next thing, right? Now, accused is committed to stand trial. In this case, preliminary inquiry is not mandatory and it is available either on the request of the Crown or the Defense Counsel. So you would see I have used acronyms DCCC, but I have also defined them. So let's say if you were to get confused between what is CC, what is DC, I have used first defined these acronyms and then sort of used them in the following pages. So PI can be given because the Crown is asking for PI or the Defense Counsel is asking for PI. The main purpose of PI is for the benefit of the accused, right? This is to see whether the Crown Counsel has sufficient evidence or not. Like I said, you're trying to see whether I can swim or not, right? Or, this is your initial stage where you're trying to swim. It is conducted at an early stage. DC wants to know exactly what CC has against the accused. This is very important where PI is not available. In this case, it's not mandatory and available on request. Okay? In some cases, like I said, PI is not available. It is not available to you as a matter of right. Before 2021 or 2022, PI was available in pretty much every case. But then they soon realized that it creates a lot of backlog and nothing really comes out of it. So then it got restricted to only grave offenses. Now, where PI is not available, in this case, indictment is preferred once the accused elects to be tried in Superior Court of Justice, because the choice of court where I want to be tried lies with the accused, right? Once again, if PI is not available, then which kind of charging document you will file depends upon which court the accused has elected to be tried before. Does this make sense? So, in situations where PI is not available, when will the Crown prefer an indictment? When PI is not available?
Once accused elect to be tried in
Before?
the SCJ.
SCJ. Because can you prefer an indictment before OCJ?
No, only SCJ.
Correct. So when we talk about PI, it is either available or it is not available. Correct, Rima? PI is either available
Yes,
or PI is not available. If PI is not available, then then how will you decide which charging document needs to be filed?
Accused.
Does what?
Accused elect.
Elects SCJ, and
Yeah.
then you prefer a PI. Then you prefer
Yes.
indictment.
Indictable.
Is this clear to everybody? Baini, am I making sense? Yasmin, Polya, Richa, Inyola, Priya,
Yes.
Pahul, Samreen, Tilda, Nuike, you've just joined, OG, Hartaj, Henry, you are all joining for the first time. Yoshi, like I said, once you go from here, if this is clear, superb. I've done my job. Yes, Yasmin, I will explain it once again. Yasmin, PI is called preliminary inquiry. Preliminary inquiry is only available in certain offenses. It's not available to you as a matter of right. And what are the kind of offenses where PI is available? Well, PI is available where you are looking at an offense which is extremely grave and serious. The magnitude of this offense is huge. So if PI is not available, right, then what kind of charging document you will file, the Crown files, depends on the election of the court that is made by the accused. Because which court am I going to go to? Where do I want to be tried? That election is given to the accused. The accused has the choice to decide where they need to be tried. Now, this might sound a little confusing. Let's say if it is a basic offense like theft under $5,000. Now, in this case, accused cannot try that I need to go to SCJ. Election is not available. Criminal code is very clear on it, right? And then there are Section 469 offenses, which is murder and manslaughter and first degree, second degree. In this case, again, accused does not get to elect. Accused will be tried before SCJ. However, there is a category of offenses, like I said, hybrid. Most of your criminal code, most of the offenses fall under that category. So once the accused has decided, where am I going to be tried? Because the offense is hybrid and the accused has the election, has the right to elect. Once they elected, that's when then the court is decided. Yasmin, is this clear now? Then they will
Thank
talk
you.
about
Thank you. Thank you.
whether the indictment will be preferred or not.
Yes, I just want to be sure.
No worries. Now, direct indictment. Direct indictment occurs before the accused has been given the opportunity to request for a preliminary inquiry, or where preliminary inquiry has started but is not concluded, or preliminary inquiry was conducted and the accused was held, it was held that the accused is not required to commit to trial. The trial may or may not happen. But in this case, because of the seriousness of the offense, the Crown can still have a direct indictment. It, in a way, deprives the accused from receiving a full-blown preliminary inquiry, right? And it is not easy to get direct indictment, let me tell you. It's not something which is a given. No, it's not. Direct indictment requires personal consent of the Attorney General or the Deputy Attorney General and can only be granted under 4 circumstances. Security of the witness is threatened, abuse of process causing delay, saying that if preliminary inquiry is conducted in this case, it's clearly going to cause delay. Well, you have multiple accused in this case, more than one accused, and you need to try the co-accused together, or it's going to prejudice the Crown's case. Only in these circumstances do you go to direct indictment. And even when the results of preliminary inquiry are not in Crown's favor, they can still go in for direct indictment because of the seriousness of the offense. And let me tell you, it's not easy to get direct indictment because you need personal consent of the Attorney General. So we are looking at really grave offenses or Deputy Attorney General. And it is granted in these 4 circumstances. Security of the witness is threatened. It's going to prejudice Crown's case. You have more than one accused that need to be tried, and preliminary inquiry will constitute unnecessarily delay, thereby leading to abuse of process. I am going to give you an example of these offenses. They're typically Section 469 offenses, Yoshi. You see, straight indictable offenses. Like I said, I'm going to talk about it. Now we are going to talk about offenses. What are the various types of offenses? 3 types of offenses: summary conviction, straight indictable, hybrid. Summary conviction. In this, the punishment is 2 years less a day. So they do not get full 2 years. They get 1 day or lesser than 2 years of, punishment. Maximum fine for an individual is $5,000 and maximum fine for a corporation is $100,000. Least serious offenses, penalties are usually not provided. So theft under $5,000 is a summary conviction offense. Summary conviction offenses don't go before SCJ at all. Then you have straight indictable offenses. These are very, very serious offenses where the punishment is codified. The punishment for that specific offense is given in the code itself. That's what they say, codified, which will tell you if this is the offense, then this is the punishment. The criminal code gives you the offense and the punishment. These are straight indictable offenses. And if in the event the offense does not carry a punishment, then the punishment for an indictable offense is maximum 5 years. These are straight indictable offenses. Like I said, Yoshi, first degree murder, second degree murder, manslaughter, any terrorist act, all these are straight indictable offenses. So if you really want to get direct indictment, you first have to establish how grave the offense is. You're going to establish any delay is going to prejudice the Crown's case. You're going to talk about the security of the witness being threatened. You're going to say that PI might lead to delay, thereby causing abuse of process. So it's not easy to get a straight indictable or a direct indictment at all. You need permission. You need the personal consent, not the permission, personal consent of the Attorney General or the Deputy Attorney General. Then these are hybrid offenses. Hybrid offenses, like I said, Crown decides how we are going to proceed. Yes, Imi?
Sorry, Hen, I just wanted to confirm which Attorney General. Is that the Provincial Attorney General or the main Attorney General?
As in? I did not understand.
Yeah, because I know every province has an Attorney General, right?
That is the Attorney General.
Okay, so in this offense, do you use the main Attorney General, the Federal Attorney General, or the provincial one?
So, see, like I said, as far as the Attorney General is concerned, and we are talking about criminal code offenses here, right? So anything that falls within the Ministry of Attorney General. So that Attorney General, the person who heads that, signs it.
Okay, thank you.
Zoom King, somebody by the name of Zoom King has just entered the class. So when we talk about hybrid offenses, these are Crown elect offenses, right? Maximum penalty is 10 years or less. Crown chooses the procedure. It can proceed summarily or by way of indictment. So these are offenses that are elected. How the Crown is going to, or which procedure the Crown is going to follow, will depend upon the Crown. And it can choose to proceed summarily because there is not much on there, or it can choose to proceed by way of indictment. 3 types of offenses. Can somebody quickly recap? What are the 3 types of offenses? Quick recap. Yes, Rima?
Summary conviction, straight indictable, and hybrid
Okay.
offenses.
What is the difference between summary, indictable, straight indictable, and hybrid?
Summary are less serious. They are for 2 years less a day. And straight indictable accused Crown does not have to elect. Those are very grave offenses for the punishment of maximum 5 years. Crown does not have an option.
No. Punishment for 5 years if the code does not
If
mention the
yeah,
punishment.
yeah.
Hmm.
And in hybrid offences, the Crown may elect either the offence as a
Summary.
summary offences or a straight indictable offences.
Beautiful. Who else is going to quickly recap these offenses for me? Only Rima got it, nobody else? No one else? Or can I pick up anybody at random? Okay, I'll pick up. Madhur. Madhur, are you here? I don't think Madhur is here. Dia?
So summary conviction is 2 years less than a day. When it comes to maximum fines, they go up to 5,000. If it's a corporation, then it's 10,000, and it's the least serious.
100,000.
Sorry, 100,000. And then hybrid offenses is when the Crown elects the offense. The maximum penalty.
Crown elects the procedure, how it will decide to pursue.
Okay, so they elect whether it'll be summarily or it'll be indictable, and it's 10 years less a day. And then straight indictable are they're just serious, very serious offenses, and they're codified with imprisonment and other penalties. And the maximum punishment is 5 years.
Correct.
If it doesn't have an yeah.
Penalty coded.
And yeah.
Kedisha. Kedisha, your turn. Kedisha, are you here?
Yeah, I'm here.
Please, yes, please tell me the types of offenses. Like I said, I'll pick people up at random just to see if the concept has landed. Yes.
Okay. Three types of offenses: summary, straight indictable, and hybrid. Summary is the less serious offenses under $5,000, up to $100,000 fine, two
If it is
years.
a corporation.
Oh, if it's a corporation, and 2 years less a day. The the straight indictable is
Can the
very
accused
serious.
decide which court they want to get tried in case of summary?
No, summary offenses is OCJ.
Absolutely, yes.
Yeah.
Continue.
And the hybrid is the Crown may elect the procedure, that is how to proceed, whether by summary or indictable, and it's 10 years less a day. That's all I remember.
That's okay. That's fine. So long as you can retain even a bit of it, that's what matters. Pahul, yes. Types of offenses, please.
Summary, indictable, and hybrid. Summary would be for 2 years less a day. For an individual, it will be up to $5,000, and for a corporation, $100,000. Indictable would be for graver offenses, and if it is not coded, it will be up to 5 years of imprisonment. And then hybrid will be depending on the decision of either the Crown Counsel or the Defense Counsel.
No, the hybrid is for the Crown Council. They decide how to proceed. So, in which of these two elections is not given? The accused cannot elect which court?
In the summary one.
Summary, and straight indictable.
Got
Straight
it.
indictable, always SCJ, summary, always OCJ. It's the
Okay.
hybrid where the accused decides. Clear?
Yes.
Yes, Vasu.
I thought, let me also try.
Absolutely. I mean, I don't mind if all of you try. But you need, like I said, if you get this correct, you have no idea how easy my job is. So please go ahead. Yes.
Yeah, so three different types of offenses.
Offenses.
Starting with indictable, summary, and hybrid. Indictable are for SCJ. Summary goes to OCJ. Hybrid, the Crown decides,
Okay.
right? And indictable are the most serious types of offenses, which can include you know, like things like murders and kidnappings. Summary can be a smaller scale, like small thefts and all that stuff, trespassing and everything. Hybrid can be a mix of both.
Yes.
And the jury. So indictable has jury as well as judge involved. Summary has no jury, only judge. And hybrid, uh, the
The
count
accused
decides.
accused decides the mode of trial.
No, but who decides, judge or jury?
Accused decides the mode of trial.
Okay, got it.
Yes,
And
Yoshi. Yeah, good. Yes, continue.
yeah, the last one was the punishment. So
Yeah.
above 5 years in indictable, less than 2 years.
If it is not coded, because if it is coded, then whatever is given in criminal code.
Hmm.
Okay, yes.
Okay, yes, that's about it. Yeah, thank you.
All right. Yes, Yoshi?
Hello, Hannah. So,
Yes.
as per my understanding, there are three type of offenses: summary conviction offenses, number two, indictable offenses, and number three, hybrid offenses. So far as summary conviction offenses are concerned, they are very least serious offenses, as you gave the example of theft, and the punishment here, the
Theft
fine
under
is
$5,000.
okay, yeah, theft under $5,000, which is typically tried in the provincial court, and it is without a jury because jury is not allowed in OCG. And this carry a general maximum punishment of 2 years, less than a day. And for the indictable offenses, they are very serious offenses like murder or assault, sexual assault, and these providing the accused with more procedural options, as you said, such as the trial by the judge and jury. And these are the very heavier sentences like the imprisonment, life imprisonment. Hybrid offenses, they are the middle ground 50-50, where the crown prosecutor has the discretion to elect whether to treat the crime as a summarily or as the indictable based on the facts of the case. So, and apart from this, least, yeah, for straight offenses, these offenses are the codified in the criminal code itself, and these are for imprisonment and penalties both. And where the offense does not carry a punishment for indictable offense, then the maximum punishment is 5 years. For hybrid, that I already mentioned, the maximum penalty which is left, that is the 10 years or less, and the crown chooses to proceed by the way of either summarily or the indictment. Yeah, that is my
Beautiful.
understanding.
Superb. Spot on. I am just so happy that, like, this is I wish I could tell you how absolutely crucial this aspect is. Like, if you get it, you know why I say this? Because let's say if you're getting a question about criminal procedure in the exam, because that constitutes a part of litigation process. But your clarity about offenses caught, if that's missing, you will always get your answer wrong. Litigation process is the backbone of barrister's exam, right? And therefore, if there is any sort of, if these basics are not clear, then which answer you're going to pick up will always be wrong. Always, always. You won't know whether what kind of bail would be offered. Is it reverse onus or not? You would not know whether preliminary inquiry is available or not. If you're not aware of the offense, you would not know where to institute an appeal if there is a conviction. You would not know what kind of sentence would be given, right? So from your sentencing to your bail to your PI to if what kind of pre-trial applications you can bring in. Everything is related to, have I been able to identify the offense? Have I been able to identify the document? Have I been able to identify the court? So that's what I'm saying. This is so important. And we are going to do questions after this. So let me see if I can just do a couple of questions right away. Okay, yeah, let's do at least one question. What is my policy for questions? Am I going to read them?
No, we read them.
Thank you, Amy. So are you volunteering? Oh, Vasu raised his hand. So, sure, go ahead, Vasu.
Okay, all right. So question one, Sam has been charged with indictable offense that is not listed in either section 469 exclusive jurisdiction or section 553 absolute jurisdiction of the criminal code. Sam is facing a potential sentence of 16 years of imprisonment if convicted. He is presented with following options for how this trial may proceed. Trial by a provincial court judge without a jury or and no preliminary inquiry. Second option, trial by a superior court of judge sitting without a jury. Third, trial by a superior court of justice judge sitting with a jury. Sam elects to be tried by a superior court of justice judge without sitting with the jury. The prosecutor does not oppose his election, but after some deliberation, both the accused and the prosecutor request a preliminary hearing before the trial. Which of the following statements is true with respect to the proceedings? A. The preliminary hearing can only be requested by the prosecutor, not the accused.
Okay,
B.
stop. Do you think it's a possibility?
No.
Forget about, do you think this is even a possibility?
No.
So this answer is wrong. We eliminate as we go, right? This answer does not make sense. Yes.
B. Because the offense is punishable by 14 years or more of imprisonment, both the accused and the prosecutor have the right to request a preliminary hearing.
This is a possibility, correct?
Yes.
Third.
A preliminary hearing is not available in cases where the accused elects to be tried by a superior court of justice, judge with a jury.
Doesn't make sense.
No.
Yes.
Last preliminary hearing will not be made available if even if Samantha requested because it is at the discretion of the crown.
No. So then what is the correct answer? It falls down to B.
B.
The most logical answer. Like literally nothing else is making sense. And that is how you're going to focus. We always do this in our regular class. I go like, tell me first which of the following options are even legally sound. We could clearly eliminate all three.
Can you explain why is B is the right answer? Just to relate with what we have.
So we spoke about preliminary inquiries given in really grave offenses, where we're talking about your sentence is 14 years or more. I'm going to talk about that aspect. So if you know that the punishment is 14 years or more, this gives you the indication that it's not a light offense, correct, Vasu?
Yes.
And I also said PI can be requested either by CC or by DC.
So
Anybody
it's a
can.
so it's an indictable offense. 14
It
years.
is it is a serious offense.
Serious. Okay.
Okay. So PI, is it available to you as a matter of right? No. Preliminary inquiry is not available to you as a matter of right. It can, how can it only be requested by the prosecutor when it generally benefits the accused? This sentence is wrong. Do you see what I'm trying to say, Vasu? We
Yes.
studied, right, that preliminary inquiry is for whose benefit? For accused's benefit. So why will Crown ask for it? Or we just studied it is available either on the request of the defense counsel or the Crown counsel. The main purpose of PI is to benefit the accused to see whether CC has sufficient evidence or not. So when we go here, we know all three options. The other don't even make sense. They are against the very grain of criminal procedure. Do you see what I'm trying to say?
Yes, got it.
Okay. Let me see if there is any other question that we can do at the moment, or will I have to teach a little bit more? No, because the rest will require some sort of understanding. No worries. So we were talking about how hybrid offenses, where it's a Crown elect offense, maximum penalty is 10 years or less. Crown chooses the procedure. It can choose to proceed summarily or through indictment. Crown screening brief that is received from the disclosure. Who prepares the Crown screening brief?
Police.
Police.
Absolutely right. But it says Crown screening brief, so shouldn't Crown be preparing it?
No.
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 That
Crown
is for
screening.
them to screen it. Prepared by police, but they screen it basically to
Yes.
accept it.
So Crown screening brief is received from the disclosure. It discloses the Crown. How am I going to proceed further? If the trial is before a summary conviction court, then it is presumed that the Crown has decided to proceed summarily because there is not enough on there for the Crown to allocate its resources. And, they go like, there's not much evidence. So, because there is not much evidence, we are going to proceed summarily. Now, let's look at what is Crown screening brief? What does it contain? It is a document that's prepared by the police which contains the synopsis of the offense, exactly what happened, background information about the accused, witness statement, police officer statement. So, Crown's screening brief is a detailed document which sort of tells you everything about the offense, right? So it gives this information in chunks that also helps the Crown strategize. How do I proceed? Where do I go? Where is the evidence going to be? What kind of further investigation might be required by the police? So it's like an overview of exactly what happened, which allows the Crown even to strategize. Based on Crown screening brief, the Crown Counsel will decide whether to proceed or not. Okay? So it is that document basis which the Crown takes the call and how it wishes to pursue. If it at all it wishes to pursue, or if I am going to pursue, let's say I have decided to pursue, then how am I going to pursue? If the Crown decides to pursue the case, then it prepares a charge screening form. The charge screening form lists the charges that have been imposed on you, not on you, on the accused. Any person who's charged by the police officer, after the charging in a few days, they prepare the Crown screening brief, and this is handed over to the police or to the Crown, I'm sorry. The Crown then completes the charge screening form and prepares disclosure for the defense. So, I need you to see the process in your head. If you can visualize it in your head, you understood. Offense gets committed, police comes to the crime scene, prepares the Crown screening brief, shares whatever information they have. The Crown prepares the charge screening form and the materials that need to be given to the defense counsel. This is a part of disclosure that needs to be given to the defense counsel. So, can you see that? Can the Crown decide not to disclose something? Can they say, no, this is not important?
No.
No.
No, you cannot.
No.
And this is also against the rules of professional conduct. If it is found that you have not shared everything that needed to be shared, please save your license first. Whatever inquiry will happen, will happen. Non-disclosure, it's a massive offense. You can lose your license. So disclosure is mandatory. Can you bury evidence like an important piece of evidence?
No.
No. So that is where, when I talk about these concepts merging with rules of professional conduct, you need to be tight here. I'll give you an example. Sometimes we get jollies, and this will happen when you're doing your practice questions. I'll get a text at 11:30 in the night from a student or from a candidate, and then they're going to say, this is the question, but my answer is wrong. And after reading the question, I'd say, where were you searching for this answer? The criminal code does not provide for this. There is not, the materials don't give the answer. That's the first thing I get. The materials don't get the answer. I said, which material are you looking at? And the person says, criminal law material. I said, but the answer is in rules of professional conduct. You are looking at criminal law, but the answer is in PR. So did you check the rules? No, we did not. I said, that's why your answer is wrong. So it is important to then focus on if you will, so the entire question is about disclosure. The entire question is about what Crown is doing and giving you unnecessary details, bombarding you with details that you don't even require, because the answer is in some rule 3.3 of confidentiality, which you didn't read because you were told not to read the rules. So please, first of all, read the rules. Make reading of rules your life. Whoever says don't read the bylaw, don't listen to them. Then they're not giving you the correct advice. Second, the question might be on disclosure, but the answer is in PR. So, and you know how we did questions in family law. Unnecessary details I gave you, which was a really long question. Like, why is she even giving us these details? Because nothing was needed in that question. And that is exactly how I need you to prepare. When you're reading this, what are you going to keep along with your criminal procedure, your materials? What is it that you're going to keep next to it?
Professional responsibility.
Rules, yes, please. You're going to tie them down. Bylaws, yes, rules. Once you'll start practicing, you will end up reading the rules a lot more than you'll end up reading the act or the statute. So you'll end up spending time doing case law research, and then you'll end up reading the rules. That's the most you'll spend your time on. Now, what does charge screening form? Now the Crown has to prepare it. What does it contain? The charges, like I said, under what sections you've been charged, the manner in which it elects to proceed. Is there a chance for diversion or peace bond? What this means is diversion and peace bond are two of the types of sentences that are imposed. Okay. Now, these are not sentences in how we know sentences. The purpose of these two sentences is to take the person out of the criminal justice system. Let's say because the offense is minor, because this is their first offense, or because the offense was not very grave, or because the person might end up losing their job and livelihood and it's something really minor, or they're very young. Now, in this case, they check if diversion can be given or peace bond can be given. So I've explained these two terms over here. Diversion is when you're offered a chance to do something like community service or counseling to have your charge withdrawn. You would have seen sometimes on traffic signals, you would have people who carry that stop sign and who help pedestrians cross if the signal isn't working. Sometimes they are those who are being asked to do community service, right? So then in that case, this is given, or so some counseling, some community service. They're asked to work in seniors' homes to have your charge withdrawn, which means your charges are dropped permanently, or they're stayed, which means they're put on hold. So this, they offer this kind of sentence because they believe and that the person can be given a second chance. Or peace bond. This is where it's a criminal court order which is made by a judicial officer that requires a person to keep peace and maintain a good behavior. So whether diversion or peace bond can be offered is given in the charge screening form itself. When we're going to talk about sentencing, let me show you. Sentencing is one of my favorite topics, to be honest, because this is where I get to see equity, which is something that I champion a lot. See, people say that there are no charts, and I'm like, your criminal law has at least 8 charts in it. Let me talk principles of sentencing. I want to talk about types. Yeah. So when we look at different types of sentencing orders, this is where you'll get different types of sentencing orders, right? So when we look at sentencing, especially when we're looking at peace bond, or we're looking at Diversion. They are specifically given in case, one second. They're specifically given when, why is it not taking the right page? Yeah. They're specifically given when the offense is not very grave or it's their first offense, etc., etc. That's when you check, the Crown evaluates if there is a charge on peace bond or diversion, and Crown's position on guilty plea. Just, I know we've not reached here, but allow me to ask you a question. Let's say I'm the accused in an offense. I go to Janet. Janet is my counsel. I go like, listen, I'll just plead guilty. Janet knows I have not committed the offense. I also know that I've not committed the offense. And I say, listen, Janet, I'm tired of it. I just will plead guilty and end the matter. Can Janet take instructions from me?
No.
No.
Under no circumstances. So when we talk about guilty plea, I'm going to talk about the specific PR rules that are applicable to guilty plea. It doesn't matter whether, no matter how frustrated I am, if I have not committed the offense and I know it and my counsel knows it, then I go to my counsel and say, listen, you know what? You know I've not done it. I know I've not done it, but I really don't want to get stuck in this mess. I want to come out of it. I'm tired. I'm exhausted. It's telling upon my mental health. No reason is good enough for Janet to say, okay, plead guilty. No. Right? So what would be Crown's position on guilty plea? For those of you who are not familiar, because some of you come from civil law jurisdictions, guilty plea simply means that the accused is ready to plead guilty. And because the accused is ready to plead guilty, the Crown says, okay, you can plead guilty to a lesser offense. For instance, if the accused has committed a first-degree murder and they are ready to plead guilty, then the Crown will say, okay, if you plead guilty, we are going to pursue manslaughter and not first-degree murder, which means, and manslaughter carries a punishment of 3 years. Don't quote me on it, but I think it's 3 years. So now what happens? The accused has committed first-degree murder. The evidence is very clear. The Crown tells the accused, if you plead guilty, you can do it to a lesser charge of manslaughter. So that means they both are meeting, there's a meeting of minds, so to speak, because you're pleading guilty to a lesser charge. For those of you who have studied foundations from me, I'm referring to a case here. And based on that, it was imperative to file a certain kind of report. Who's going to answer that?
Administrative suspension.
GLADU report. Remember? R versus GLADU.
Sorry.
If someone says you don't remember GLADU report, especially I know some of you have done foundations from me, I would be very upset. Rima, GLADU report?
Yes, I do remember.
Pled guilty to manslaughter when she had in fact shot her boyfriend, remember?
Yes, I do.
So that is GLADU report. The other thing that you need to know about guilty plea is that the judge is under no obligation to accept it. The judge can toss it. But if a judge rejects a guilty plea, they have to have a very good reason for it, right? So when we're talking about guilty plea, first of all, guilty plea is not, you're not dangling a carrot in front of the accused. That's not what you're doing. You're trying to say, listen, you're saving my time. You're saving the resources. So because you're agreeing to plead guilty and we're not going to have a full-blown trial, you can plead guilty to a lesser charge. So it's an incentive. Second, the court is not bound by it. The judge is not bound by it. The judge might say, you know what, this doesn't look like guilty plea because you've been unnecessarily harsh with the accused, or you're letting the accused plead guilty to a summary conviction offense when they've committed manslaughter, really. So the judge is not bound by it, right? And if they want to reject the guilty plea, which they can, then they have to have a very good reason for it. And at no point in time can an innocent person plead guilty because they are tired or exhausted, because they cannot afford, etc., etc., etc. Okay. So the charge screening form will also give the Crown's position on guilty plea. Okay. The charge screening and disclosure lists one of the three possibilities. One is Crown decides to proceed summarily. I don't think I need to just explain this. Crown decides to drop the charges. Once again, I don't think I need to explain this. Crown proceeds by way of indictment. Now, when Crown decides to decide to plead by indictment, there are three possibilities here. Number one, Crown Counsel recommends diversion. This is usually given to young people, and some programs are suggested. There is no criminal record. Crown Counsel recommends a peace bond, usually given to a first-time offender. Again, no criminal record. Crown Counsel offers guilty plea. If the accused accepts early guilty plea, the option is given to the accused, and the Crown usually offers lesser punishment, right? When we talk about proceeding by way of indictment, there's something called the absolute jurisdiction, which means if you are convicted of one of the offenses, which is a Section 553 offense, OCJ has absolute jurisdiction, and here the accused does not have the right to seek PI because, well, what PI would be available to you if you've committed, if you've stolen $2,000? Accused does not have the right to election if the theft is less than $5,000. But if the theft is more than $5,000, now it is a hybrid offense. So a hybrid offense means the accused has a right to ask, they have a right to decide where they want to be tried. And this is based on information charging document. When we talk about Section 469, this is exclusive jurisdiction. First is absolute. OCJ has absolute jurisdiction. Exclusive jurisdiction, which means only SCJ. This has absolute jurisdiction over the matter. You have to proceed by way of indictment. This is a very serious offense. Accused is tried presumptively after PI is requested and is available by a judge sitting with a jury. If you don't want the jury around and you want a single judge to try you as the accused, you will need the consent of the Attorney General. No right of election. So you see, 553 and 469, you're not being given any choice because the matters are these. You cannot tamper with the jurisdiction of the court, right? If you have a Section 554 offense, accused may elect to have the trial before OCJ. It is here when the accused has the right of election. If it is a 554 offense, accused can say, I want to be tried before OCJ. No problem. And the accused can say, well, it is a hybrid offense, but I want to be tried before SCJ. No problem. It is a hybrid offense, but I want to be tried before SCJ and with a judge and a jury. No problem. It's a 554 offense, hybrid, choice is yours. Pick up the mode of trial. All right? The choice of trial is with the accused. Does this make sense? Choice of trial is always with the accused. Yes, Rima?
And now the section 553 offenses are tried in OCJ
That's right.
because they are summarily or because
Convicted.
they are.
No, because they're also less serious, right? So they will
But why do we
require, yeah.
why do we then mention proceed by indictable? That means it was first hybrid, right?
No, 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 no. I'll give you an example. We're talking about summary conviction offenses, right? Where, one second, I'll show you which you're talking about. 553 of and criminal code. So let me read out the section to you. This is an absolute jurisdiction. So jurisdiction of provincial court judge is taken into account, and this is with theft, theft other than cattle theft, obtaining money or property by false pretenses, unlawfully having possession of any property, or thing or any proceeds of any property or a thing, knowing that all are part of the property or thing of proceeds. As you can see, really simple offenses. Gaming, betting, 202, 203, 206, 209. These kinds of offenses are Section 553 offenses. Do you see? They are absolute jurisdiction. Now, why did I write it over there? Because if the theft exceeds $5,000 and the accused decides to go by to an SCJ, then can you have a summary conviction there, Rima?
I haven't understood your question. Can you repeat?
If the theft is over $5,000,
Okay.
where then is it OCJ?
Yeah, no, it's not
No.
OCJ.
No, it may still be OCJ because it is not a 469 offense, right?
It becomes hybrid, right?
It becomes hybrid, right?
Okay.
And when
Because
it
the
becomes a
offense was less.
no, when it becomes hybrid, then, and if the person says SCJ, then where do I go?
You can choose your mode of trial.
Choose.
Okay.
Do you see, Rima?
Okay. Yes.
So
Now I got it.
when you're reading look at 553 as an offense. If you see what kind of offense are we talking about here? Theft other than cattle theft, mischief, counseling or conspiracy to or attempt to commit or being with an accessory after the fact to the commission of any of the offenses that are listed, gaming, betting, pool sealing, bookmaking, placing bets, lotteries, etc., etc. Fraud in relation to fares. So these are really, really simple offenses.
So
So
we can say that absolute jurisdiction is not summarily, right?
absolute jurisdiction, Section 553, are those offenses that are being tried before Ontario Court of Justice. All right?
Not because
So
they were summarily at the first place, but because those were
correct.
chosen by the Crown. Okay.
Yes.
Thank you so much.
Yeah. Yes, Dia?
Sorry, I just want to clarify. So when it comes to hybrid offenses, you have the right to choose mode of trial, and when it's 469, it's you can where you can choose a PI.
No, I mean, PI, you cannot choose. You have to ask for it, and if it
Yeah,
is available, it will be given to you.
Yeah, the Crown or the accused can ask for PI, but when it's a hybrid, then it's you can choose to elect your mode of trial.
That is right.
Okay.
So, election means the accused has a right to select the court of trial. Now, when you initiate via information. Information means it's going to be in OCJ. When police gives, so we said that it is based on the first-hand information, right? So either the police will give you the swear, or the informant you'll get the information from the informant. So if the police gives the information, it starts with a swearing. Remember I said it's a sworn document. Where did it go? Sworn document by the police officer. So if it is by the police, it's a sworn statement that is given by the police. So it starts with swearing. There are reasonable grounds to believe that offense has been committed. Accused is not present when the cops give this information. Police officer, however, may serve appearance notice. Appearance notice is a document that informs the accused what they have been charged with and the details of when do they need to appear before court for the first time. So first appearance in the court, and it's very less serious matters, the kind of matters we just saw. After the appearance notice is given, the police then swears the information before the justice. This is justice of peace. The justice either confirms or cancels the allegations. Now, appearance notice can be given immediately by the police before the information, or it can be given even after. No problem. When a private person gives the information, this is when the information comes from another person who's not a police officer. Then once again, this is given based on the information on oath. If it is a Section 504 offense, what is a Section 504 offense? Section 504 provides that anyone may lay information under oath before justice when they have reasonable grounds to believe that the person has committed an indictable offense. So this requires that such information be referred to a provincial court or to a designated justice. Test for issuing process in this case is more stringent. And Attorney General receives a copy of this information. They also receive a notice of hearing, and they have the opportunity to call witnesses and examine cross witnesses before this actually sort of becomes into a full-fledged thing, because you are trying to assess whether the information that you have received is genuine or not. If the judge refuses to issue process, then no information needs to be laid unless you get new evidence to support the allegation. It is here that, they want to be very sure, do you have some sort of a personal vendetta against the person? Why is this information coming from you? Were you a witness to the offense? Did you call the cops? Or when you say you have reasonable grounds for believing that an offense has taken place, what are those reasonable grounds? Right? So it is in a person's case, they are a little more skeptical, and therefore they end up doing their due diligence. Information, now this is very important, and I need you to focus on this. Let's say somebody gave information against me, right? When they gave information against me, the Attorney General conducted a hearing. There were witnesses, cross-witnesses, a cross-examination of witnesses, everything was done. After hearing the information, the judge said, sorry, we are not going to take any action because we don't have enough evidence against Henna. Cool. But the information, let's say, comes from A. A says, but the thing is, the offense has been committed and you're not ready to take any action against her. So what I'm going to do, I'm going to file a mandamus. It's a writ. I'm going to file it in Superior Court of Justice. And now the judge over there will tell you, Do your job. Mandamus simply means do your job, right? So the informant, and in this case, A, is very unhappy. A is like, but she committed the offense, and none of you are ready to listen to me. And the Attorney General has not done a good job with their witnesses. And even though they did, the judge still feels that the evidence is sketchy. The judge is refusing to take action against her. So the informant is very angry. The informant wants justice. So where does the informant go? The informant in this case will go to Superior Court of Justice to compel the judge at OCJ to issue process. However, the informant cannot sit on it forever. This application for mandamus needs to be brought within 6 months of an in-camera hearing. So an in-camera hearing means the hearing is not open to public, right? So the informant is not happy with how the hearing was conducted, and the judge has refused to issue process, saying we don't have enough to issue process against Henna. So now, unless you get me fresh evidence, informant, I'm not acting on this. Informant is very angry. Informant or feels aggrieved, decides to go to Superior Court of Justice, but the informant cannot go a year after the information, the in-camera hearing has taken place. Informant only has 6 months of time to file for mandamus. Mandamus is you file the application before Superior Court of Justice, which simply means compel the OCJ judge to issue process. Mandamus is a very common tool when you're doing immigration. A lot of people, they file mandamus against IRCC and the immigration department, saying that they've not taken a decision. You would have seen this. You would have heard, oh, we got a favorable mandamus order.
Yes, we have.
Yeah, it's a very, very common tool when you're doing immigration. Because now you're asking the government authority to do their job, right? So in this case, you're unhappy with the decision. The in-camera hearing got conducted. The judge says we don't have enough against Henna to issue process. Where will the informant go?
SCJ
For
SCJ for
what?
mandamus. Mandamus, right?
to
After
file
10
a
years?
mandamus.
After 10 years?
No,
6 months.
6 months. Within
Six
6 months.
6 months of what? 6 months of giving oath?
6 months of in-camera hearing.
Beautiful. Now, if let's say Crown has given information, in this case, the Crown needs to stay charges after information has been given, but the charges cannot be withdrawn until the completion of in-camera hearing, because they have to wait for what the judge has to say. Now, when we talk about initiating by way of indictment, I think I spoke about direct indictment being preferred by AG, right? What are the 4 circumstances under which AG will allow direct indictment? We did
Abuse
that.
of process,
Okay.
witness
Delay.
We started this half an hour ago.
trying a number of accused together,
Yes.
PI has commenced but wasn't concluded.
No, that's
prejudice
not.
to the Crown's case,
Yes, prejudice. Yes, prejudice to Crown's case. Security of witness threatened. Multiple accused being tried together.
abuse of
Abuse of
process,
Abuse of
process.
causing
power.
delay.
Yes, yes, absolutely right. So in these circumstances, direct indictment. But what do you need? Consent of Attorney General or a Deputy Attorney General. No preliminary inquiry is available. Crown prefers indictment on charges contained in the information at the time the accused person has made election retrial. So in this case, regarding trial, what happens is the information was given, right? Sworn information. Crown says there is enough on here. We are going to proceed by way of indictment, right? And the Crown can only proceed by way of indictment once the accused has made an election regarding trial. So let's say the Crown is waiting for the accused to elect the mode of trial. Accused elects OCJ. Can Crown prefer an indictment?
No.
No.
No. So in this case, the Crown holds back its decision, waiting for the accused to decide how they want to be tried. Clear? In case of direct indictment, what is the first thing you need?
Consent of Attorney General and
Absolute
Deputy
or
Attorney.
Deputy Attorney General. Gorgeous. Second, if PI is not available, then whether the Crown decides to prefer indictment or not depends on
The election.
Mode accused.
election. Yes. Mode of trial that is elected by the accused. Guys, am I making sense or am I speaking a lot of Latin here? Latin, Greek, Portuguese?
It makes sense.
You're making
sense. And post preliminary inquiry? After preliminary inquiry, the indictment is prepared by OCJ on the charges stated in the information. Judge can order the accused to stand trial. Now, why is OCJ preparing charges here?
Because PI is in OCJ.
And
Yeah.
yes, because PI is conducted in OCJ and the judge can order the accused to stand trial. Now, is this clear? Everybody? Post preliminary inquiry, no PI available, direct indictment. Yeah? Yes? Okay. Rules of indictment and information. Section 581, sub 1. Each count in indictment must in general relate to a single transaction. So each count, when we say 3 counts of murder, 2 counts of break and entry, what does it mean? That means the transaction or that thing happened twice. Does this make sense? So when I say 2 counts of murder, 2 counts of assault, 3 counts of something else, what's happening? That means 1 count means 1 occurrence. 1 count means 1 transaction. I mean, transaction here is, when I use the word transaction, it basically means occurrence. Okay? Offense must be known to law. 1 offense per count. I just explained the concept. Commission or omission must be categorically identified. Did you commit something or you failed to commit something? That needs to be categorically identified. Now, let's talk about motions. What are the different motions that you can bring? First of all, when we talk about motions, there are 2 types of motions. Motion to quash, motion for particulars. You see, motion of particulars is filed when there is insufficient information. I'm going to also discuss this when we're doing civil litigation. Sometimes you file for a motion for particulars, saying that, the information that you've given is so sketchy that I cannot make my case here. So motion to particulars is then filed for. Motion to particulars says, listen, Crown, no information. I need more information. What did you collect? Whom did you interview? You've not given me anything. The other is motion to quash. Motion to quash means, the word quash simply means nullify. It needs to end. What you're saying makes no sense. Motion to quash. This may be brought where information on indictment is deficient in its face. You're like, you know what? There are literally no details on it. So how about we quash this? Second, must be brought before the accused has entered a plea. And later, if you want to, um, if later, if you want to bring a motion to quash, you can only do so with leave. What is leave? How will you define leave?
Request.
Permission.
Permission,
Permission
yes.
from the court.
So the first time when you are filing a motion to quash, it has to be before the accused has taken a plea. But if after the accused has taken a plea, then you can file a motion to quash after
Permission.
you've
Leave
taken
has been granted.
leave has been granted. Yes, absolutely right. They're not available to you as a matter of right. And this is, you're basically talking about it's defective, so on and so forth. Court has the discretion to amend the defects, and it may allow the accused without causing any prejudice to to the accused. Or the count fails to give reasonable information. So these are the two motions you can bring. Either you can bring in a motion for particulars saying, you know what, the information that you've shared with me is so deficient that it does not give me the opportunity to prepare my defense at all. Or, you know what, I'm just going to quash this because it's senseless. And if the accused has already taken the plea, then I will first go to the court, seek permission, and I'm going to say, you know what, the information or the indictment here is so patently defective that it needs to be quashed. Now, the court can say, all right, we have the discretion to allow for amendments. So the Crown will go back and amend the defects. And you know what? During this time, we can perhaps grant bail to the accused because we don't want the accused to be prejudiced. So the court can sometimes allow for amendment provided it does not prejudice the accused. Or when you know what, the count does not even give me enough information, you're just creating facts out of thin air, motion to quash. Elections. Elections are only available in 554 offenses. What are 554 offenses?
Hybrid.
Hybrid offenses. So it is only available there. So are you trying to say that if it is a first degree murder, I cannot elect my mode of trial?
No, it's a
No, it's serious.
You can't.
Are you very sure of that?
Yes.
Crystal clear.
Oh my God. Amy does not. She's like, Hannah, you're wrong. Come on.
Absolutely.
Get your act together, woman. You're wrong. This is what she says. No, 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 no. You don't know your law. Now, this can be given in the form of a trial by a provincial judge, a trial by a superior court judge with jury, or judge and jury. Now, where can election be given as a right? Now, I need you to remember these timelines, please. When the trial is 60 days, more than 60 days away, the accused has a right of election as a matter of right. You don't need written consent of the prosecutor at all. All right? Where does the election require notice? Well, the accused will have to provide notice to the same judge before whom the accused made the election. Now, where does election require consent? You see, when the trial is more than 60 days away, you don't need consent. But if the trial is less than 60 days away, now you need written consent of the prosecutor. And requirement of the notice is the same. You have to go to the judge, the same judge, before whom you elected first. And if the prosecutor does not consent, no re-election is possible. So election is, as a matter of right, is given when?
Hybrid offenses.
Yeah, but as a matter of right, when, in terms of timeline?
60 days.
60 days.
It's more than 60 days.
What is more than 60 days?
If
Trial.
Trial.
right. But let's say the trial is more than 60 days away. I have elected to be tried before OCJ. Do I need consent of the prosecutor?
No.
You're very sure. But what if the election is less than 60 days away? What if I make the elections much later in the process? Then what do I do?
If it's less than 60 days, then you need consent.
From whom?
The prosecutor.
From the prosecutor.
Crown prosecutor.
From the
Written
crown.
consent.
Yeah.
Written.
But if the crown prosecutor does not give me the consent,
Then no re-election.
clear?
Yes.
This timeline is important. Remember that. No notice, sorry, no consent if it's 60 days away from trial. Consent if less than 60 days away from trial. Notice requirements are the same. You need to give notice as a notice of how you're going to try or what is your election needs to be given to the same judge before you are, so in that case, you need to give notice. No preliminary inquiry under OCJ offenses. Indictable offense, Section 469 and Section 553, no right of election. Now, I need you to focus on this, please. Yeah, I think even though, okay, let me just try if I can do this because I want to finish this today. So let me just focus. Deemed election. Now, deemed election is when the accused has failed to elect and if the provincial judge declined to record the election by the accused. In two situations, there is deemed election. Number one, provincial court judge declined to record the election. Number two, the accused failed to elect. In this case, there is deemed election, which means the matter will now go to SCJ and that's it. All right. So in this case, sometimes the provincial judge may decide that the matter needs to be tried before SCJ because of capacity issues, because of complexity involved. In that case, election for with or without jury. In this case, the election is made with or without jury. So plenty of candidates want to know, why will provincial judge decline? Because of the complexity of the matter involved. In this case, the provincial judge will say the matter needs to be tried before SCJ, no matter what. Now, the only election is whether you need to be tried with jury or without jury. So if it's deemed election, then it simply means you're going to be tried by a judge and a jury. Deemed election simply means that the accused did not elect, so the matter is going to be tried before SCJ with judge and jury. Or because the provincial judge said that the matter is very complicated and needs to be tried before SCJ only, right? In this situation, the election then becomes whether it should be with jury or without jury. That's all. If direct indictment under 577, if it's a direct indictment, the accused again has deemed to elect judge plus jury. Now, re-elections, which means you first elected in provincial court, you first elected that I want to be tried before OCJ, and now you are re-electing. In this case, notice and consent both are required to change the election to another mode of trial. That means you had already elected OCJ and now you are re-electing. So in this case, you are going to change the election to another mode of trial and therefore notice and consent both are required. Re-election timelines are the same. If it's 60 days before the first date of trial, you really don't need any consent of the prosecutor. If it's less than 60 days, you need the consent of the prosecutor. Now, if you elected SCJ and you're re-electing, which means in first case, we were moving from OCJ to SCJ. Now we are moving from SCJ to OCJ. So in first case, we are going up. In second case, we're going down. So if you elected SCJ and you are re-electing, if the matter is before SCJ, original court is Superior Court of Justice and the accused wishes to be tried before OCJ, then the accused requires a written consent of the prosecutor. Timelines don't apply at all. Even if the trial is more than 60 days away, it doesn't matter because the matter is going from higher court to a lower court. If preliminary inquiry is not conducted yet, provide the notice to the judge who's presiding over the preliminary inquiry. Because let's say if the preliminary inquiry has not been conducted yet, then you are going to give this notice of election or re-election to the judge who's conducting the preliminary inquiry. If the preliminary inquiry has been conducted, then you must provide a notice to the judge before whom you made the election. So if you're going from SCJ to OCJ, then we are going to ask whether PI has been conducted or whether PI has not been conducted. If PI has been conducted, provide notice to the judge who before whom you made the original election. If let's say PI has not been conducted, then you will give the notice of re-election to the judge who presides at PI. In this case, timelines don't really apply because you're going from a higher court to a lower court. Beni, you had raised your hand. What can I do for you?
I just wanted to know under what circumstances an accused can elect to go from a superior court to an OCJ.
Because they want to, because they think they have a higher chance, because they think that an OCJ judge would be able to give more time. Because OCJ judge sometimes, there is no jury. So they'd be able to, so I mean, it can be plenty of reasons.
Okay.
There can be plenty of reasons. Perhaps you just want to be tried by a provincial court judge. You don't want to go to a superior court judge. So that can happen.
Got it.
Or, it comes to you, perhaps your counsel has advised you that this is perhaps this is a better venue for you. It can be multiple reasons.
Got it.
Any questions, anybody? Yeah, no, but SCJ gives you the option of not being tried by jury at all, right? Yasmin? So, Yoshi? So, not necessary. Yes, Imi?
Yeah, so I just wanted to confirm. So, in the event that you re-elect and you go back to OCJ and you fail, you lose the case, can you appeal and go back to SCJ?
You can appeal against the decision, but you cannot re-elect.
Okay.
Right? Let's say, see, again, in criminal law, plenty of people think appeal is available to you as a matter of right. That's not the case. Actually, some of the most, and you'll read about this, very seasoned counsels sometimes end up getting their appeal rules wrong because they were like, oh, we tried, so once I made the election, I cannot go in for appeal. No, you can. You just need to you need to figure out under which section you want to appeal. And then because there are two sections and you cannot simultaneously appeal under both, then depending upon which section you want to go under, you can still appeal because here you're appealing against the decision, Imi. It's not a question of election anymore. Do you see what I'm trying to say? So they cannot say, oh, you cannot appeal. That's not a possibility. Because over here we're just restricting your election. The trial hasn't even happened and you might not be happy. So it does not impact your right to appeal. Okay?
100%. Thank you.
You're very welcome. All right. Now, if it's multiple accused, where you have more than one accused, If there are more than one accused, elections will not be considered. If the accused persons select different courts, all of them will be deemed to be tried by judge and jury because this is seen as a delaying tactic. One accused wants to go here, the other accused wants to go there. So either you all come to the table and decide one court, but if all of you have decided different courts, too bad, judge and jury deemed election. Because people used to use this, like, I was told, I'm not, don't quote me on this, this is actually a delaying tactic. So in order to avoid that, they say, since you are not able to arrive at the decision, we will decide for you. This is common in case of robbery where there are more than one people involved. Attorney General requires a jury trial. Now, in this case, Attorney General can require a jury trial where the offense is punishable by more than 5 years. If this is the case, then preliminary inquiry is necessary. These are some really serious offenses where the Attorney General says, listen, we need to have a jury here. Now, in this case, because the offense is grave or because the offense is such that it's come into public limelight and you know that they're genuine, not just individual, but also the reputation of the profession, the confidence in the administration of justice. There are other things at stake. They'll say, we are requiring a jury trial. Now, in this case, the offense has to be such that it is punishable by 5 years, more than 5 years, which means it's really, really serious, right? And if this is used, a preliminary inquiry must be held. So this I have done as a quick recap for what we have studied in the table. And this is necessary because sometimes, like I'd give you my example. I'm not very good. Like I really want them written down as well. Apart from table, I also want it in a sentence form. So this is for those who find sentences more friendly. If you want to go from OCJ to SCJ, check the timeline on the trial, whether the time is less than 60 days or more than 60 days. If the time period is more than 60 days, then no written consent of the prosecutor is required. If the notice of intent to re-elect is required, you only require a notice of intent to re-elect, and this is given to the judge before whom you made the election. Now, if the time period is less than 60 days, then you need written consent of the Crown Prosecutor along with the notice. All right? If you want to go from SCJ to OCJ, check if PI has been concluded or not. If PI has been concluded, then notice is mandatory and it needs to be given to the judge before whom you made the election. If PI has not been concluded, then provide a notice to the judge who presides over the PI. This is basically done in the interest of time. Notice at all times will be required if you move from SCJ to OCJ, notwithstanding the timeline. Also, consent is always required. So here there is no 60 days. Here we're talking about 60 days timeline. Now, what are your PR aspects? When you first meet with the client, you need to discuss the costs, the legal fee, and the disbursements involved. Right? The client should not get a surprise when they see a $200,000 bill lying on their desk. If the accused is economically weak, ask them to apply to Legal Aid Ontario. And you have some income thresholds for that, which I think got recently updated. Don't quote me on the number, but I think it's $40,000. I think. But like I said, you'll have to check. But this is not, you don't really need to. I'm just saying if the accused is economically weak, they need to apply to Legal Aid Ontario. If the accused qualifies, which means their income meets the threshold, or it's below that threshold, the Legal Aid Ontario will issue a certificate. Yes, Vasu, what can I do for you?
No, I just wanted on that legal aid qualifying criteria. I believe there are different thresholds depending on the size of the family and
But that's for
the,
family law, right? Not for criminal law.
oh, same will not be applicable.
No.
Oh, okay. So
Because
if
family law thresholds are different. Criminal law
oh, okay,
thresholds are
okay, okay,
different.
okay.
It's
Thanks for
different.
clarifying.
It's a
Okay.
different, so that's why you have legal aid for criminal lawyers, like
Oh,
for
okay.
criminal legal aid for immigration. Somebody had reached out to me a couple of days ago saying, do you know somebody who does legal aid for immigration? And I was like,
Mm.
I don't take on legal aid files. Even when, I mean, even independently, I don't take on legal aid files. So I'm not really sure. That's why I said, don't quote me on income thresholds, but I think it's $40,000. I could be wrong,
Yeah. So
but
you're saying that thresholds are different for each field of law. Criminal is separate, family is separate, everything is
yes,
kind of.
I think so. The reason I'm
Okay.
saying this is because family has two people, right?
Yeah. Two or more. Yeah.
Right, but criminal law can be one.
One. Okay.
I mean, I can be single, right?
Yes.
So then I know that the income thresholds vary. What they are, I don't know. And frankly, even you don't need to know. Not
Okay.
for your
That
exam.
is what is more important. That there's
Not for
no
your exam.
code. Okay.
So and you know, people who do legal aid are very familiar with these income thresholds. I'm not, because I I don't take on legal aid files.
Okay.
And if the accused qualifies, the Legal Aid Ontario issues a certificate. Legal aid's certificate allows the accused to retain a counsel who retains legal aid clients. So not every counsel retains legal aid clients. And lawyers are responsible to Legal Aid Ontario regarding the accused's financial circumstances. So if, let's say, there is an upgrade, you have to let legal aid know if you're aware of it. Now, I'm just going to touch upon youth criminal justice system, but I'm not going to do it in detail. Youth, like I said, there are two types, right? Separate for adults, separate for accused. In case of young offenders, we are looking at Youth Criminal Justice Act. It's also known as YCJA. So when I talk about YCJA, as you can see, it's a defined acronym. When I say YCJA, I'm talking about Youth Criminal Justice Act. Now, in this case, the accused must be over 12 years and less than 18 years. The age is calculated from the date when the offense was first committed. In other words, if the crime was committed when the person was 17 years, 11 months, and 25 days old, they would still be tried under YCJA. And the youth court judge is known as youth court, right? We don't have separate youth courts in Canada. Judges of OCJ double as youth court judges. Uh, no charges are levied if the accused is less than 12 years of age. If, like I said, if the person commits an offense at 11 years, 11 months, and 29 days old, still no charges will be filed, right? In the next class, we are going to dive deep into YCJA, and I'm also going to give you a little bit of history about YCJA because it was not the first statute that dealt with young people. So we're going to talk about YCJA. Please go back and listen to the recording from November 2025. So we're going to wrap up youth criminal justice. I'm going to talk about what are the circumstances, when can a custodial sentence be given, who prepares the pre-sentence report. So we're going to dive deep into that. And then I'm going to start talking about investigation a little bit in terms of who conducts it, etc. But of course, we are just going to touch the surface. We are going to dive deep into investigation next Saturday, which is April 11th. That's when I really want to sort of get ensure that this is done in detail. Can we do some questions, please? If you're not tired. Okay. I need people who are going to read. So, who is going to volunteer? Madhur. Pahul, are you interested in reading? Or
Yeah,
giving a
for sure.
Excellent. Let me pick up. Pahul is there, Madhur is there, Beni would do it. Oof. Hartaj, are you interested in doing a question? Are you interested in reading a question? Hartaj Dylan, you've been awfully quiet. Amy can do it. I don't know if Hartaj is there. Dave, would you be interested in doing a question? Not sure if you're here. All right, so we do have candidates who have no worries, no worries. So we'll start with Madhur and then Pahul and then Beni, Imi, and then I'll pick up one person at random. Yes, Madhur?
Yes.
1 second. Yeah.
Jason and Kyle have both been charged in a joint information with the same indictable offense. Jason elects to be tried by a provincial court judge without jury, while Kyle elects to be tried by a superior court of justice, a judge with a jury. The Crown does not oppose the election of either accused, but the judge notes that the elections may result in complications for the joint trial. Given the information above, which of the following statements is most accurate regarding the proceedings and the potential for severance? A. The trial must proceed with both Jason and Kyle being tried by a provincial court judge without a jury, as this is the election made by Jason. The court may refuse the elections made by Jason and Kyle for trial by a provincial court judge or judge without a jury and may deem both accused to have elected to be tried by a judge and jury. Defense counsel must immediately apply for a joint trial severance under Section 591 of the Criminal Code to protect Jason's and Kyle's right to a trial within reasonable time. Severance under Section 591 of the Criminal Code is not available if both accused have made different elections for trial, as law requires a joint trial. I think there'll be a deemed election. Oh, sorry, deemed judge and jury one.
You sure?
Yes. Both judge and jury.
Yeah. B.
Yeah.
Multiple accused.
Yeah.
Good. No, not this one. No, not this one. 1 second. I will take out different set of questions. No, not these. Just give me a minute, guys. I want to practice different set of questions with you guys. Yeah. Pahul, your turn.
Ready. In a small town of Maplewood, a local shopkeeper, Mr. Thompson, reports a theft to the police, stating that a customer, Alex, was seen leaving his store with a stolen item. Mr. Thompson, however, did not witness the theft himself. He was in the back of the store when it occurred, but claims to have seen the video footage that corroborates his suspicions. He decides to file an information against Alex. Mr. Thompson approaches Justice Carter of the OCJ to lay the information. He swears an affidavit stating that based on video evidence he reviewed and the suspicious behavior of Alex, he has reasonable grounds to believe that Alex committed the theft. Which of the following statements about the process of laying the information is true? Mr. Thompson must personally witness the theft to lay an information against Alex. The justice is required to investigate the truth of Mr. Thompson's claims before accepting information. Mr. Thompson can lay the information based solely on hearsay evidence from another witness. Mr. Thompson can. Sorry, 1 second, there are messages. Okay, Mr. Thompson can lay the information if he believes on reasonable grounds that Alex committed the theft, even if he did not personally witness the act. It'll be D.
Absolutely right. Beni, your turn. You ready?
Yeah, I'm ready.
Superb. Yes.
Okay, on July 15, 2019, during a local festival, Sarah was charged with a summary conviction offense under the Provincial Offences Act for causing a disturbance in a public place. The charge falls under a section that does not specify a penalty. After a series of delays, her trial is set for October 10th, 2019. The court finds Sarah guilty of the offense. During sentencing, the judge notes that because the offense occurred before the change in penalties took effect on September 19, 2019, the applicable maximum penalty is 6 months imprisonment. The judge then considers the general penalty provisions under Section 787, subsection 1 of the Criminal Code, which state that the maximum term of imprisonment for summary conviction offenses is now 2 years less a day. Which of the following statements regarding Sarah's sentencing is true? A. Sarah can be sentenced to a maximum of 2 years less a day because her offense falls under the general penalty provisions that applies after September 19th, 2019. B. The judge must apply the maximum penalty of 6 months since the offense was committed before September 19th, 2019, and the specific penalty for her offense is not provided. C. Sarah is not liable for any fine since the offense was changed under the Provincial Offences Act, which does not allow for fines. D. The general penalty provision allows for a maximum fine of 10,000 for summary conviction offenses.
All of you gave the right answer. Good. Amy, your turn.
Tom is charged with theft under $5,000 for allegedly stealing a bicycle from a local park. The charge falls under Section 334B of the Criminal Code, which is categorized as an indictable offense under Section 553. After being arrested, Tom appears in the Ontario Court of Justice, where the Crown lays an information against him. During his first appearance, Tom's lawyer argues that he should be entitled to an election regarding the mode of trial, but the judge informs them that for offenses listed under Section 553, such an election is not available. Tom's lawyer is also informed that there will be no preliminary inquiry for this charge. Which of the following statements regarding Tom's case is true? A. Tom has the right to elect to have his trial in the Superior Court of Justice instead of the Ontario Court of Justice. B. The judge must conduct a preliminary inquiry before Tom can be tried in the Ontario Court of Justice. C. Tom will be tried in the Ontario Court of Justice without the option of a preliminary inquiry or an election regarding the mode of trial. D. The charge against Tom will require an indictment to be drafted and filed in the Superior Court of Justice.
All of you gave the right answer. It is C. No election and OCJ and no PI if it is a 553 offense. Okay. With this, we come to the end of our session. I hope you all found the session useful. For those of you who are our regular students, please go back and listen to the second recording from November 2025 sessions. Thank you for all the hearts. Keep coming them in. I like them. And you're very welcome, Pahul. You're very welcome, Yushi. I'm glad you liked the session. And start reading if you have your previous year's materials. If you don't, you already have access to the notes. Start reading them, start making your own notes. Ensure that the concepts settle down. Play with concepts a little bit here and there so that, you're always in touch with what we are doing. Since we are through with family law, do not forget to allocate some time on a weekly basis to revise what we've done so that they stay with you. All right. Please check the website. Now, when we talk about your mock exam for family law, I will conduct it after the materials have been released. So I'll give you a date and Then we'll also have a mock exam for criminal law. We will have a mock exam for civil, so that you are familiar with how to answer questions. You already know that in the mock exam, you will be given a minute. I don't care if LSO gives you a minute and a half. In this class, you will have to answer the question under a minute. So that's you need to be prepared for that.
No, you didn't have to. Now you realize that I'm in class.
So with this, our class comes to an end. Hope you.
Tina, can I request you to maybe go back to the first question? I do not recall the rationale for the answer.
Which?
Uh, where there were two accused, and there was a severance.
Yeah, I'll come back to it.
Sure.
With this, we come to the end of our session. I'm going to stop the recording. Please go back and listen to the recording. And I'm going to see you on Monday for our next session on criminal law. All right? Take care and bye-bye.
7:30, right?
Yes,
Thank you.
you're very welcome.
Hey, Hannah.